It's not only interesting, but quite noble. The only trouble is it's going to meet some difficulties from a practical point of view. And the first difficulty would be encountered in the Constitution, which provides that everybody has a right to adequate housing. So, and it says everybody, it doesn't put a particular bias towards women. That's not the only and most significant challenge. The current legislation does recognize that there has to be some effort to promote the interest of marginalized women in the provision of housing. That's good, but you can't put too much emphasis. You can't have a blanket. So what the problem with what the Honourable Minister intends to do is have a blanket bias towards women, whereas that's not what the current Act is. It's not a blanket one. It's just to say, amongst the many things, you have to promote the interest of marginalized women. The other difficulty is when it comes to our matrimonial law, that's the laws governing divorces and issues of custody of the children, as we now call it, primary residence of the children. It doesn't follow that the mother receives primary residence in respect of the children. Actually, the mother and the father have got an equal and 50%, exactly, so they have an equal chance of getting custody in respect of the child.
And we also see lots of cases where children choose to live with the father. What then happens to protecting the child?
Absolutely. So you see, the blanket nature of the proposed amendment would not cater for that eventuality, because it doesn't follow that the mother automatically has primary residence of the child, or as it popularly known, custody of the child. So that's the big difficulty I foresee.
I also foresee some difficulties, Michael. You know, from a layman's perspective, what happens if there's more than one wife?
Absolutely, which is the reality we live with. But often if there's more than one wife, there'd be more than one house allocated. So I think that's less of a difficulty than the primary difficulty of elevating women beyond men, such that it is done in a blanket manner. The other difficulty is men have an equal chance of getting custody of the children. So we'll have situations where the man is now sitting with custody of the child, but the mother enjoys the benefits or the use of the house.
Same-sex marriages?
Absolutely. So it obviously wouldn't cater for that eventuality as well. And that's one of the things that have to work very hard at. In fact, I can't see this working out as blanket as it is. I do see it. When you look at the current Housing Act, it's not blanket in its formation. It says promote that. Of course, we want the promotion of the interest of marginalized women. Everybody wants that, and everybody agrees that it's not contrary to the Constitution to promote that. But to then have it in a blanket form would present difficulties.
And what about the clashes with customary law? I mean, we know sometimes a divorce may happen in court, but it hasn't happened, you know, traditionally, or vice versa. You know, how do you get past that kind of
Well, the distinction between customary law and civil law is very quickly becoming sort of not visible, because, you know, we don't have a situation where the man's family would inherit or live with inherit the property at the exclusion of the wife. It would be that the wife would also enjoy inheritance. So at divorce, you split it between the two. It's not a situation where the woman previously would leave the household with what she came with, as what the Honourable Minister is proposing. Previously, you would have had a situation where the wife would have to leave and go back to her family with only the clothes on her back.
All right, very quickly for us, Michael, we're almost out of time. Just what needs to be done here? Then maybe she needs to sort of look at the word husband and wife, and maybe the words themselves need to
Well, as far as I'm concerned, with the current wording of the current Housing Act, the purpose can be achieved, you see, because if you say, if you do it at an early stage where you have a bias towards single mothers, this Act would allow for that, and you say our policy is to give preference to single mothers. The current Act allows for that. If you then say, but if she gets married, we want to have a different regime, we want to have a different in-community of property, you can't have that, because if she does get married, the single mother, it would mean, and she chooses to get married in community of property, that property would be shared. So if anything, you might want to educate the beneficiaries of these houses to say, if you're going to get married, try not to get married in community of property, because you would lose that. So more education than an amendment, in my view.